When you are going through the hiring process and have an additional agreement from the recruiter or hiring manager, get it in writing. I'm talking about any oral agreement beyond the standard contract. If possible, have the contract amended before signing, or at the very least, get something in writing stating your additional agreement. An example of this is asking for unpaid vacation time to attend a wedding right after you start, or that you need a lunch or a break at a specified time each day to pick up your child. This may happen when you're talking to the recruiter or the hiring manager. If you only get a verbal agreement, you have no legal grounds. If you need an additional consideration when being hired, make sure you have that added to your employment contract, or again, at least get it in writing in some other way. In employment law, there is something called parole evidence rule. It's essentially that a written contract will always be favored over a verbal contract. If there is any things that contradict, modify, or vary from that written contract, they will not be considered. There's even what they call a merger clause that is often added to a written agreement that solidifies that a contract is complete. Thus, there's no room for additional terms. I've seen this happen many times where a new employee had asked about a specific need with their schedule or some specific time off needed for some event. They get agreement from the recruiter or the hiring manager, but their new managers aren't aware of this, and there is no obligation for them to honor this unless you have that accommodation in writing.